Hi, I'd like to welcome you to our fifth and last colloquium for the 2013-14 academic year. I want to welcome Professor Avigail Eisenberg from Political Science and Cross-Coded in Indigenous Government. And she's going to be giving a talk on how religious freedom is changing, changing religious freedom through citizenship. Changing citizenship through religious freedom. There it is. And one last thing before we get started, I just want to thank all the members of the Colloquium Committee that aren't standing up butchering people's titles. So in addition to myself, we've had Dustin, Stephen, Reagan, Alita, Dominic for the first portion of the year, and Carol's also, although she's not been on the committee, been here every time helping out. So I just want to thank the rest of the committee for allowing this to happen. And the only last thing I want to do is plug the conference, which is coming up on April 25th and 27th. Thinking is a Way of Life. Registration is now open, and the program, I believe, is online. So you can go to the website found under that name and see more. Without further ado, I'll hand it over to Abigail.
Thanks very much. And I'm going to do something that's going to mess with your camera. Not quite. I'm going to grab my glasses because I'm kind of in between glasses prescriptions, and it depends on how far away this is, whether I need them or not. So that's much better. And Mitch didn't really butcher the title because there is no title. And I'll tell you the inspiration of this paper. A friend of mine who is at Osgoode Hall Law School wrote in the context of, and actually he used to be here at the law school, Ben Berger, wrote in the context of a paper he was doing the phrase that the state uses religious freedom, or religious freedom is being used to reinscribe state sovereignty. And I thought that was really evocative. A lot of things that Ben writes is like that. I highly recommend reading his stuff. It's really interesting if you're interested in sovereignty and culture and religion. And so what I thought about that phrase quite a bit, and I thought about unpacking it. Ben hasn't unpacked it yet. And so I thought, what does that mean? And what would it look like for the state to use religious freedom to reinscribe its sovereignty? So that's what this paper is about. But it's couched in terms of a project that I've been working on for a couple of years. And that is about the way in which there's been a shift in how rights are protected in the last 50 years. And probably one of the most significant changes in the way in which rights have been protected and accommodated in Western democracies has occurred due to the shift in legal and political approach taken by the state to religious freedom. So it's really religious freedom that has been at the center of this. Whereas religious freedom was once treated as crucial to the individual's freedom to choose their most deeply held beliefs and to follow their conscience, it's now treated by some states as an unchosen identity, similar to a cultural identity or ethnicity, maybe similar even to gender, which has to be accommodated in order to treat people fairly. So while choice and identity, which are the central two concepts in this paper, are not mutually exclusive perspectives, what I refer to as the choice and identity approaches have different political aims, impose different obligations and pressures on political institutions, motivate distinctive types of ideas about citizenship, about what it is and what it could be. So what this paper does is it explores how religious freedom is a leading means by which citizenship is being reshaped today. And as a large and growing scholarship shows throughout the world, religion is used by the state to reinscribe its sovereignty and to establish its sovereign control over the public sphere in a way that was not true 50 years ago. In this context, debates within states about how to accommodate religious freedom can be helpful in tracing the political dynamics of a new formulation of citizenship. So the first part of this paper talks about these two approaches, that is choice versus identity. And I'm going to situate it, because I'm a Canadianist, I'm going to situate it within Canadian scholarship and Canadian jurisprudence, what's going on here. In the larger project, I actually look at it in relation to Europe and the United States as well, but I'm not going to do that here unless you're interested in that. You can ask me questions about that. And the second part looks at I think I have 3 implications here. There are 4 implications of the shift, and that's it. So no problem solving today, just setting up the problem. So what about choice versus identity? So when religious commitments are understood as personal choices, the aim of the law and the aim of the state will be to ensure that individuals are protected to choose to follow their religious beliefs, to choose to adhere to their practices. That's what the law actually will do. So, for example, the choice approach does not prohibit the state from having a religion. So you could have, like Britain and Canada, have a sort of a basic adherence to religious beliefs generally. You could have that, or actually we used to, where the Lord's Prayer was said in public schools, where in God we trust is put on money, for example. All of those things could be in place, and you could still have a choice approach to religion, as long as no law prohibits people or stops people from choosing to practice their religion if they want. Now, the choice approach comes with a really interesting proviso, and this was, by the way, the approach that Canada adopted until about 1980. The choice approach comes with an interesting proviso, and that is that you have to be free to make your choices, but the state doesn't have to compensate you for the choices you make. So, obviously, if the state has a religion, and that religion requires that all stores close on Sunday, as they used to in Canada, according to the Lord's Day Act, the state would say, or basically the idea from the law is, if you're Muslim or Jew and you want to close on Friday or Saturday, you have to be free to do that. That the law requires that you also close on Sunday is neither here nor there. You don't get compensated for your choices. You just have to be free to practice the religion that you want to adhere to. And that's the choice approach. So the choice approach is that you have to be free. There can be no law that prohibits you, but that the state does not have to provide you with compensation. So the great case on this is a case called Edward Books, which happened around the time that Canada got its charter. And let me just quote, I had some slides to show you these quotes from these cases because they're really stark how the change occurs. But the change occurs here's what the court said in Edward Books. The economic harm suffered by a Saturday observer who closes shop on Saturdays is not caused by the Lord's Day Act, which requires that people close on Sundays. It's the result of a deliberate choice of a tradesman who gives priority to the tenets of his religion over his financial benefits. So according to the choice approach, freedom of religion does not require that lawmakers eliminate every state-imposed cost associated with the practice of religion, or that religious faiths are treated the same way by the state. In a religiously diverse society, freedom to choose one's faith often involves costs of various kinds, and unless those costs are covert obstacles to prohibit people from practicing their religion, citizens should not expect the public purse to subsidize their choices. So that's the choice approach. Now, in contrast, when religion is treated as identity, the significance of religious belief changes. As part of an identity, religious practice can no longer be regarded as a choice, but that an individual has to absorb. But rather, it's viewed as an immutable, non-negotiable aspect of who the person is, like their ethnic background. And as a result, the law must respect that religion in order to respect the person whose identity is informed by it. So using an identity approach, religion becomes part of who I am rather than what I choose to believe. A law that privileges the practice of one religious group over another, such as a law that requires businesses to close on Sundays, violates religious freedom. because what it does is exposes minorities to disrespect and disadvantage, or it can deny them dignity. So if a court, under an identity approach, if a public institution like a court is convinced that having a law like a Sunday closing law leads to a kind of disrespect and disadvantage for non-Christian groups, then, according to the identity approach, that law should be struck down. That law is unconstitutional. So that's exactly what happened in Canada with the case called the Lord's Day Act. So the Lord's Day Act operated, and it was struck down precisely on that basis. And the court said, in proclaiming the standards of the Christian faith, the Lord's Day Act creates a climate hostile to and gives the appearance of discrimination against non-Christian Canadians. The theological content of the legislation remains a subtle and constant reminder to religious minorities within the country of their differences with and alienation from dominant religious cultures. So quite a difference between those two perspectives. The shift, again, to choice from choice to identity is a shift from looking at it, you have to be free to choose, we don't care what you choose, if we're the state, we don't care what you choose, we're not going to give you compensation, to a very different perspective in 1985, in a case that said, no, actually, we're going to treat religion as part of who you are, not as something that is alienable from you, but as part of who you are. And so a state law that fails to include you or fails to show equal respect for your religion or favors one religion over others shows disrespect, potentially exposes you to disesteem and disadvantage. And is non-inclusive and potentially marginalizes you. Entirely different citizenship regimes in my mind. One is a citizenship regime that is based on individual choice and liberty, classic American liberty, and one is a regime based on democratic inclusion and concerns about marginalization and differentiated citizenship. Okay, so let me just say a couple of things about why this shift occurred, just so you know that this is not a Canadian phenomenon in all respects. Very briefly, the reason why we get this shift in 1985 is because, it's because of the Charter of Rights and Freedoms. Pretty obvious. The Charter was passed in 1982. It's the first time Canada has entrenched a set of rights into the Constitution. It emboldened courts to take very different approaches and to think about rights in very different ways. And so all sorts of groups in Canada became mobilized, not just in 1982, but also before 1982 in Canada, leading up to the Charter, because they saw the Charter as a kind of panacea for some of their concerns and problems. And it wasn't just religious minorities. In fact, in the scheme of things, religious minorities were not very active. The groups that were greatly active and who viewed the Charter with some optimism included women, people with disabilities, gays and lesbians, Indigenous peoples at first, interestingly. They were very optimistic about the Charter or about the Constitution changes. So what occurred in Canada was kind of a renaissance, a rights renaissance, and people started looking at the Charter and rights as a way of resolving what I call renegotiating the terms of citizenship. But of course, Canada's experience can't be thought of in isolation, because what is going on around the 1970s and 80s throughout the world is a similar kind of mobilization, which is sometimes called, or what I call, the age of identity politics. And the age of identity politics is an age where the politicization and mobilization of a diverse array of groups occurs on the basis of features of identity, including gender, race, language, ethnicity, sexuality, religion, and indigeneity. Since around the 1960s, in many Western democracies and elsewhere in the world, in non-Western democracies, various groups have been making claims before domestic and international courts for recognition and protection of some aspect of their identity. And in many of these cases, they want to contest the way in which they're incorporated into the state. In this context, religious minorities have mobilized. And this includes new religious minorities, immigrant groups, and in Canada that would be primarily Muslims, who are new immigrant groups in the 1980s and 90s. But also old religious groups, traditional religious groups that we haven't even heard of, that haven't contested anything. They all of a sudden become activated in starting in the 1980s and 1990s. So in Canada, we get cases having to do with the Lord's Day Act. Jews become mobilized, and since then we've had many cases about the Sabbath, Jewish holidays of various kinds. I mean, actually, there are so many cases right now in Canada because of Quebec, I don't even have to go through them all. But let me just offer you some examples in the last 20 years throughout Canada and Europe. Wearing headscarves has become a huge issue. Kirpans have become a huge issue. Censoring cartoons and other material has been an issue. The criminalization of polygamy, restrictions on religious arbitration. These issues have been important into the politics of Canada, France, Britain, Denmark, Netherlands, the United States, Germany, just to name a few of these countries. So the shift in Canada from choice to identity from a choice to identity approach to religious freedom occurs at a time when numerous groups in Canada and throughout the world are engaged in identity politics. In the last 30 years, 40 state constitutions have been changed to insert the word identity in their constitutions. And in this context, it should come as no surprise that when we revised our Constitution in 1982, we didn't revise it in some sort of timeless way. We revised it at the height of the era of identity politics. And so a lot of the sections of our Constitution completely reflect that preoccupation. And a lot of the first decisions that were made in that Constitution also reflect that preoccupation. So this is a Constitution informed by identity politics, written by people who were exercised about identity politics, who were influenced by groups, who were mobilized by identity politics. This is very much a document that is thick with identity politics. And the cases that were brought to the court were also ones like that. And the court did its due. So did its due by, for the purposes of my research, doing a wonderful job in shifting from what I call a choice approach to religion to an identity approach. Okay, so what are the implications of this? Well, I want to mention the rest of this paper is just these 4 implications. The first implication of the shift to an identity approach is that disputes about religious freedom are reframed as disputes about religious equality. And claims made by religious minorities are about renegotiating the terms of citizenship. So the aim of a lot of the cases becomes not simply to protect someone's choice, but to track and expose social exclusion and historical injustice. And that might seem obvious to you, because maybe that's what you think all of these cases should be about, but that is completely different from what went on before 1980. And I would say it's quite different from whatever went on in the American courts before around 1960. That the idea of using cases about religious freedom to track religious equality was just not ever done. So the identity approach puts on the table a more effective way of tracking social exclusion and historical injustice. And this is in part because judges, when they use the identity approach, are more inclined to treat certain features of a group's religion, such as a particular practice, for example, as an immutable part of their identity, and therefore significant to what's required to treat the group as equal. So when you use an identity approach, courts are more willing to consider the connection between the prohibition of a practice, polygamy, let's say, and discrimination against a group. Now, they're not willing to accept that as just that's what happens, but they're more willing to entertain that there could be a historical connection between prohibiting a controversial practice and actually discriminating and subjugating groups. And we actually see this. If you think about it, you have to have something like an identity approach. You have to believe that practices are important to people's identities in order to draw that connection. This is the connection that the FLDS, the Bountiful community, really tried to draw in the recent court case that they put together. They submitted historical and political evidence to show that the criminal law prohibiting polygamy was initially designed to dissuade the break-off Mormon sect from immigrating to Canada, and then to stigmatize and marginalize and exclude the group from the benefits of citizenship in Canada, the United States, in around the 1880s, 1890s. So they wanted to show that, criminalizing polygamy was not just a one-off sort of people found this to be an important practice, that this was a means by which the group was being persecuted. And similarly, and I'll give you another example that we all accept, is the criminalization of the potlatch, the prohibition of the potlatch. We just view that as part of Indigenous identity for certain communities. And so we view that as they're criminalizing a practice in order to subjugate a group. Well, this is exactly what the cases started to reveal. And it's exactly what the religious minorities started to show. This is not just about allowing a cartoon to be published, or this is not just about criminalizing narcotics, thinking about the peyote case. This is a concerted effort by the state to subjugate a particular minority group. And it's the identity approach that allows you to make those arguments, and make those arguments stick. So that's the one. That's a great benefit of the approach. And it is, you could not do it with the choice approach. Thinking about the Kirpan case, if you're familiar with that case, that's a case in Quebec where a boy wants to wear a kirpan to school. School board eventually says no. The case goes to court, to the Supreme Court. And the Supreme Court says this. It's a very big identity decision. If some students consider it unfair that G, the student, may wear his kirpan to school while they are not allowed to have knives in their possession, it's incumbent on schools to instill in their students this value that is at the very foundation of our democracy. Accommodating this child and allowing him to wear his kirpan under certain conditions demonstrates the importance that our society attaches to protecting freedom of religion and to showing respect for minorities. So, interestingly, this is the language of identity. It's not the language of choice. If Multani had been framed in terms of individual choice, the court would have focused on deciding whether the school's no-weapon policy undermined Multani's right to exercise his choice about practicing his religion. Did the school's no-weapon policy deny the right of Sikhs to choose to practice their religion? Probably not, actually. Probably not, although the court says something different in another case, because he could go to a different school. He could go to a private school. So using the idea of no compensation, choice without compensation, if that's what you used, Multani's choice was not this law did not impair him from wearing his kirpan if he wanted. But we could disagree about that, and whether or not this question would have led the court to decide in favor or against Multani. It clearly would not have led the court to consider how restricting kirpans might expose Sikhs and other religious minorities to disrespect or disadvantage in Canadian society. If you want to make the argument that the prohibition on kirpans exposes people to disrespect and disadvantage, you have to be using something like an identity approach. You have to believe in that approach, that kirpans are part of people's identities. So that's one. And I think that's a very good positive thing. I think that's pretty well the only positive thing about the identity approach. Let me tell you about the other three. The second one is mixed. The second implication is that the shift from choice to identity effectively shifts the focus of debate from a concern about injustice done to individuals to a concern about injustice done to groups. And this shift can have benefits and risks. So one benefit is that the approach helps to connect individuals to groups through collective practices, and through these group practices to a history from which injustices embedded in histories of exclusion often contained within citizenship regimes can be exposed, where they would otherwise be obscured if we focused on individuals in the here and now. So if we focus on the individual in the here and now, we sometimes miss the idea that groups are actually the subject of injustice, and that injustice can be structural and it can marginalize groups without marginalizing all members of a group. So evidence about the meaning and importance of a practice to the group helps to illuminate this collective dimension, which can be overlooked by assessments that narrowly focus on the individual believer and the individual believer's freedom to choose. And I'm not going to go into it. I'm happy to. The example I end up using is the example of the danger. And the way in which the disrespect that the way to understand that case is so much not about individual choice and so much about disrespect to groups. And you can't really see it if you don't focus on the groupist dimension of it. But there's a risk when you focus on groups. And that is that when the state focuses on groups and when public institutions focus on groups through something like an identity approach being applied in a court, let's say, the risk is that it places pressure on groups to present themselves as unified rather than divided, as homogeneous rather than pluralistic, as definable rather than fluid and variable about their practices, commitments, and in relation to who counts as a member. And that's actually one of the biggest drawbacks of identity politics, is that it places pressures on groups to be definable, unified, and homogeneous, and to choose leaders who will present them in that way. So in order for groups to make persuasive claims for the protection of their practices, they have to provide state decision makers like judges with convincing evidence that tracks social exclusion and injustice, just like the FLDS did in Bountiful. And in order to do that, they have to show that it helps to show that they are clearly identifiable through their practices and of other visible features of the group, that those who do not do this practice are really not members in good standing, which is another actually aspect of the FLDS Bountiful case that you find, is the claim that it's a voluntary practice, but those who don't practice it are not really in good standing. So there's a lot of pressure on the group to make that claim. So it's mixed. Okay, third implication. So the third implication is actually the most interesting one. And it might be the one that I end with. So the third implication is that a shift from choice to identity increases the pressure on state institutions to provide stable and publicly accepted means of assessing when and how the state ought to accommodate religious practices and values. So the need to legally accommodate religious practice tends to arise as a public issue wherever the identity approach guides public decision-making, because only where religious beliefs and practices are considered immutable, non-negotiable features of persons' identities, as opposed to choices that individuals make, will the exclusion of a religious practice be viewed as the exclusion of a group. So where religious practice are considered a matter of choice, my choice to practice something or not, it's the individual who chooses whether or not to participate in the public sphere. But where it's considered a matter of identity, then it's the state that is choosing to exclude the individual as a member of the group, and thereby the state that fails to be inclusive. So, insofar as the identity approach, when applied to conflicts over controversial religious practices, exposes the exclusion and marginalization of some citizens, it demands that the state respond by renegotiating the terms of citizenship for these groups and establishing a public sphere that's more inclusive. That's the identity approach. It requires that states do that. And it puts pressure on states. And that's supposedly the good thing, right? So that was the first implication, is that it puts that pressure. The third implication is that, okay, so how do states do this? Well, states do this by having courts that decide whether veils should be accommodated when people bear witness at criminal trials, or whether kirpans should be allowed at school. So on the one hand, states have processes by which they make these decisions. And these processes, there's a huge scholarship that shows that these processes tend to be riddled with problems and sometimes fail, and fail miserably. So some of the scholarship you might be familiar with is the scholarship that shows how sexist many of these decisions end up being, how they tend to reaffirm conservative values and patriarchy. Here what I've done is I've talked about 3 reasons, 3 problems with these processes that we end up getting. 1 is that they are intrusive, 2 is that they are conservative, and 3 is that they create mainstream anxiety. Let me put it this way. They create reactionary politics. So let me just explain these 3, and that will be the end of this presentation, okay? So number 1, they are intrusive. In order to establish the extent to which laws impact a group, or the degree to which their impact is significant, a significant source of disrespect, courts, let me just use courts for the example. Courts have to investigate the nature and importance of a practice to a group. So I'll give you an example. In all religious cases, what courts will say is that we're not going to investigate your practice. Whatever practice you say is important to you, we're going to accept it as part of your sincerely held religious belief. And then they investigate the practice often. So, for example, I don't know if you know the case of the Hutterites who didn't want their photo on their licenses in Alberta, a community of farmers who didn't want, they have a religious belief, they don't want their photos taken, they don't want their photos on licenses, they wanted an exemption from the mandatory photo on the driver's license. And the Supreme Court says we must go further and evaluate the degree to which the limit actually impacts on the adherent. The Supreme Court says, basically how important is this photo going to be? What if we don't allow you to have if we require that the photo be mandatory, what impact is this going to be on your community? Is it going to be a serious thing? So it's intrusive. Basically, the court goes to an isolated community of farmers in northern Alberta, and they have to decide, these 9 justices of the Supreme Court, what impact disallowing these people to have driver's licenses will have on the community. And, I must say, they decided, well, not so bad. You're farmers, you can all hire drivers. And that was the decision. So it's very intrusive. It's on the one hand intrusive, and on the other hand, for those people reading this decision, it doesn't make much sense. Another example is the woman who, the NS case in Ottawa, woman was sexually assaulted, claimed to be sexually assaulted by her uncle and cousin when she was a child, comes to court years later, and she is the witness in the criminal trial, and she now wears a veil that covers her face, a niqab that covers her face. And there's a law in Canada that says you cannot bear witness in a criminal trial with your face covered. So it goes to the Supreme Court. And to make a long story short, the court devises a case-by-case test, part of which requires that in some cases, when these cases arise, there be a comparison or there be a weighting between how important the right to a fair trial is in the particular case versus how important the veil is to the woman in a particular case. And so if you just imagine how that might go in a courtroom, you can imagine that there's a very accepted repertoire about how to decide whether the right to a fair trial is important. But what is the repertoire for deciding how important a veil is to a woman? How would you do that? If I was a lawyer, what I would do is I would ask, do you eat halal? Have you ever had premarital sex? Do you now live with your boyfriend? I would go through those kind of questions. Those are intrusive, brutal questions to be asking someone. And so it's very intrusive. The way in which the state has to assess a lot of these cases is they have to be quite intrusive to determine in some cases whether the practice is actually, how important it is to the person adhering to it. So that's number one. Number two, all of these processes, all of the ways in which states go about doing this tend to rely too heavily on conservative values about minorities. Sometimes these conservative values are already entrenched in the law, but sometimes the conservatism is built in right into the way in which the assessments work. So for example, in Canada, the primary way in which we assess religious freedom is through the idea of reasonable accommodation. So reasonable accommodation is the legal standard. It's the primary modality, what I would call the primary modality by which religious freedom is experienced and assessed in Canada. As a legal standard, if you don't know what this reasonable accommodation is, it says that facially neutral rules can have adverse effects, that have adverse effects on the basis of religion are a violation of the right to religious equality unless reasonable steps are taken up to the point of undue hardship to accommodate religious observance. So that's the standard. The standard in Canada, that's what we've come up with as the way in which we're going to resolve all of those cases. So basically, if someone has a practice, you have to take reasonable steps up to the point of undue hardship in order to accommodate. That standard is mainly used in court cases about employment, but I think it's used more generally as well. And legal scholars and practitioners have long recognized that reasonable accommodation is a very conservative standard, which entrenches the power of dominant groups by requiring accommodation only to the degree to which the majority is caused hardship, undue hardship. So in effect, this means that the more fundamental a rule or norm is to the dominant group's way of doing things, the less likely accommodation will appear to be reasonable, even if it causes minorities serious disadvantage. So the standard itself is a very, very conservative standard. And this is not, the Supreme Court of the Chief Justice of the Supreme Court is critical of the standard. But that's the standard we use. And it's used mainly, and if you want to think about just how conservative it is, think about how it is used. It's most of the cases in which that standard is used are not religious cases. They're cases about disability and gender. And so the idea is, and think about disability cases, for me, it's the most vivid example, that if it ends up causing a business undue hardship because, for example, it involves a great financial expenditure, a great reorganization of the way the workplace works, in order to accommodate someone with a disability, the employer will not be required to accommodate. So the standard is not inclusiveness or it's not justice. It's basically if we have built a society that entrenches the exclusion of certain people into the fabric of what's done in the society, it will be unreasonable to require that we change that. So it's very conservative. So intrusive and conservative. And Canada's standard is a great example of conservative. Finally, the last thing is that these legal standards create reactionary politics. And again, I think we see reactionary politics we see it throughout the world today. But I want to suggest that part of it has to do with identity politics, the identity politics that I am specifically looking at, specifically this shift from choice to the identity approaches. And let me take as the example the reasonable accommodation standard again. Because what that standard does, and let me explain it in the way of how it works in a courtroom. So if you take this reasonable accommodation standard to a courtroom, it invites a certain kind of adversarial dynamic, in the sense that it creates and incentivizes the employer, who might have to accommodate, to make a case if they can of undue hardship. So you're taken to court, you have an employee, she wants Wednesdays off because of religious reasons, you have to accommodate. So actually she wants Saturdays off because of religious reasons. What is your argument? You make the argument that was made in Ontario a long time ago. Will is the day I make most of my money because that's when people shop. So it will cause me undue hardship to accommodate this person. It incentivizes respondents to make a case for undue hardship. So employers show not only that accommodation will require them to change their rules, but these changes will cause them undue hardship, will jeopardize the very enterprise that they are engaged in. And this is the tendency you get in all these cases. The tendency is for employers to highlight and exaggerate the close connection between existing rules and the essential nature of their work. Firefighters end up talking about the importance of these physical fitness tests and the nature of saving people in fires. People who run drugs. I mean, it's all over the place. It incentivizes a kind of adversarial behavior. Now, consider from this perspective. So consider from this perspective the adoption of reasonable accommodation as a public philosophy about how religious freedom is going to be experienced in the public sphere. When religious accommodation is adopted more broadly as a way of thinking about religious freedom, when reasonable accommodation is adopted, and its limits in the incentive exists for those who wish to resist accommodation to highlight the undue hardship to be experienced if accommodation is required of them. So now consider from this perspective what's going on in Quebec right now. It's no surprise that the most recent campaign in Quebec to pass a Charter of Quebec Values follows soon after a Supreme Court decision, the Multani decision, the Kirpan decision, which imposes the standard of reasonable accommodation on Quebec schools, and right after the Bouchard-Taylor report on reasonable accommodation is announced in Quebec 2007 or 8. According to the defenders of measures like the Charter of Values, the circumstances in Quebec are, and here is the incentivization of the adversarial politics, those who wish to defend the Charter want to suggest that accommodating veils and kippas and kirpans will be an unreasonable hardship for the society. That is, that it will be a departure from Quebec's distinctive public culture and historical rejection of religion. That's what it is. So reasonable accommodation as a public philosophy incentivizes Quebec to make that argument. Cultural equality in that context is reduced to finding ways to insert minorities without upsetting the dominant group's position of power, as it is written in the ways that social institutions work. So the risk here is that the requirement to accommodate can best be resisted by mainstream groups if they successfully raise the stakes by showing that accommodation threatens to undermine the ideals and identity of their citizenship. In this way, reasonable accommodation can elicit a political dynamic on a national scale that limits the promise of the identity approach to religious freedom. It provides an invitation for public decision makers to emphasize the mainstream's distinctiveness as a means of highlighting what the limits of accommodation ought to be. So in contexts where this incentive is at play, even strong multicultural states committed to religious diversity like Canada will establish strict boundaries of citizenship, some of which are nearly aesthetic in the stakes they establish about what Canadian identity consists in. And here I'm thinking about recent state-led initiatives to change the rules to define identity through Canadian citizenship rules, such as who can take the oath of citizenship, how you cannot wear a veil now to take the oath of citizenship, who can give evidence at a criminal trial, veils are not allowed, at criminal trial, even whether you can wear the veil to vote. All of these things occur in a context. These are state-led initiatives to define identity through Canadian citizenship rules using a public philosophy of reasonable accommodation of religious practice. And specifically as a result of thinking about accommodation of religious practice, these particular initiatives were established. So implicit in all of these initiatives is the question of which religious practices ought to be accommodated, and when does accommodation undermine the very project that is Canada? That is the project of the oath, of naturalization, of passports, of of bearing witness at a criminal trial, which is a huge marker of citizenship and stakeholdership. So the same incentive that works in Quebec to exclude and selectively include religious minorities for participation in public sector jobs as teachers, doctors, public servants, and daycare workers also selectively includes religious minorities to enjoy the full rights of Canadian citizenship. And in both cases, reasonable accommodation, which paradoxically compels the state to respond to the historical exclusion of people on the basis of their religious practices, harnesses a latent dynamic that can encourage those who resist accommodation to prove to a skeptical court or to convince a public audience of voters that they will experience undue hardship if required to accommodate, because the very heart of their identity is at issue in these cases, which is exactly the politics I think we see. So, I've gone on for enough, but let me just say in conclusion that the dynamics that I'm looking at here are very much like the dynamics I see with identity politics more generally. That the identity approach to religious freedom has extremely positive aspects to it and carries dire risks that can be traced. The identity approach helps groups who wish to renegotiate the terms of their citizenship in the state because it provides an accessible means of tracing historical injustice. The fascination with historical injustice right now comes in the context of identity politics and an era of identity politics. The approach binds persons to practices and thereby pressures states to committed to democratic inclusion, to make public space for, that is, accommodate diversity of religions, and this kind of renegotiation could not take place where religion is considered a matter of protecting individual choice alone. But in real-world context, the shift from choice to identity is that this shift has made space for a new form of second-class citizenship. Publicly endorsed systems of accommodation, such as reasonable accommodation, can be intrusive and conservative, and have mobilized mainstream publics to define themselves as vulnerable to the changes minority accommodation might impose on them. And partly for this reason, the shift from choice to identity has coincided with restrictions on religious minorities, especially Muslims, to the basic rights of citizenship, including in Canada restrictions on voting, naturalization processes, and legal protections, and in Quebec, to access to public services, employment, and public assistance. So citizenship is thereby reshaped by a new form of selective inclusions whose origins lie with the state's use of religion to reinscribe its sovereignty. Thanks.
We have time for some Q&A before refreshments. Does anyone have a question to start?
Take 5 minutes.
I had a question about the reasonable accommodation standard. I completely agree with you about that being extremely problematic in terms of who's able to determine on rights, and then how it's sort of utilized to force people to come up with or to incentivize people in positions of power to come up with reasons why